Friends, good evening to all. Today I am going to discuss on the topic of revisional scope of the order passed under section 125 CRPC. So let us first examine the aims and object of section 125 of the Code of Criminal Procedure. Friends, section 125 of the Code of Criminal Procedure is one of the most invoked and discussed provision of the code. This code provides that any person who has sufficient means to maintain himself cannot deny the maintenance of the wife, children, and parents if they are not able to maintain themselves. Sometimes the husband against whom the order of maintenance is passed may not be satisfied with the judgment passed by the lower court, and therefore they should have a platform where they can put up their grievances against the order. Therefore, they have the right to file the revision application in the court of law as provided under section 397 of the code. The scope of revision application increased in recent times due to increasing awareness and improved outlook of the judiciary towards providing the justice to such parties as well. Let us look at the scope of the revision available against the order under section 125 of the Code of Criminal Procedure. Section 125 defines the scope and applicability. Section 125 of the Criminal Procedure Code provides for the maintenance to the wife, child, and parents. The court, after the party has invoked section 125 of the code, may order the respondent, that is the husband, to maintain the wife who is unable to maintain herself by providing monthly maintenance to her. There is an exception in the provision for the purpose of providing maintenance to the wife. The husband has to be sufficient enough to support his wife after the separation, and at the same time, the wife must not be living in adultery or living separately with her husband without any sufficient reason. Even if they are living separately in mutual consent, then also the wife will not be entitled to any sort of maintenance. Whenever the judgment is passed in favor of the wife, the court has to make sure that the husband has sufficient means to provide maintenance to the wife. The court also needs to make sure that the wife after the separation does not have enough money to maintain herself. Under section 125 of the code, the revision is available for interim maintenance, which means that during the pendency of an application in the court of law, the order may be passed by the magistrate directing the husband to pay the maintenance allowances to the wife. However, the magistrate has a right to alter the amount of the maintenance to be paid if he thinks that there is a change in the circumstances of the individual who has been paying or either receiving the monthly allowances. This laid down the case of Vikas versus State of Uttar Pradesh. All such applications of maintenance can be filed in any district where the person who is liable to pay resides, or where the wife resides, or where the person last resided with the wife or with the mother or with the illegitimate child. The purpose of Section 125 CRPC is to achieve a social purpose in society. The purpose of Section 125 CRPC was explained in the case of K. Bimal versus K. Veeraswamy, wherein it was held that Section 125 of the Code had been introduced for achieving a social purpose. The aim of this section is the welfare of the wife by providing her with the required shelter, food after the separation from the husband. It was held in this case that if the wife has lived like a wife and the husband had treated her like a wife for all the years before their separation, the wife cannot be denied maintenance by her husband. Now let us examine the scope of revision against the order passed under Section 125 CRPC. Now the revision is maintainable in the higher court under Section 397 CRPC if the order of maintenance has been passed by the court of magistrate, then the revision is maintainable before the court of session, or if the order is passed by the family court judge, then the revision application is maintainable before the Honorable High Court under Section 397 itself. Now, under Section 125 of the Code of Criminal Procedure, when the proceedings are concluded against the husband, the court tends to decide the quantum of maintenance which has to be paid to the wife after considering the circumstances of the case. Although the maintenance declared by the court would satisfy the petitioners, what if the husband is not satisfied with the order of the court? As appeal under Section 125 of the court is not maintainable, the legal option which is available with the husband is to go for the revision proceeding. But it all depends on the merit of the case, whether the party has the right to file for the revision proceeding in the higher court, but the jurisdiction of the higher court is also limited, as they have to take into consideration certain aspects before the proceedings with the revision of the case. One of the limitations is that the higher court cannot interfere when the evidence that has been presented by both the parties is taken into consideration. The power of revision is available with Section 397 of the Code of Criminal Procedure. The High Court or the Court of Session Judge has the power to call for the examination of the record of any proceeding before any inferior court. However, the power of the revision will not be applicable concerning any of the interlocutory application passed in any of the trial proceedings. In the case of Asu Dhiman versus Jyoti Dhiman, which has been passed by the Uttarakhand High Court, holding that an order passed by the trial court rejecting or allowing the application for the maintenance when the proceedings are pending in the court cannot be considered as an interlocutory order, and the higher court have the right to review the case which has been filed by other party. In case of Sunil Kumar Sabharwal versus Neelam Sabharwal, it was held that an order granting interim maintenance under Section 125 is not an interlocutory order, and therefore the revision of the same cannot be barred under Section 397 2 CRPC. When the court has straightaway rejected or allowed the proceeding to be filed in the court of law, then the parties should have the right to go for the review by the court of law. Numerous judgments have been passed by the court and provided that even if the wife is capable of earning or is earning, cannot be denied the maintenance by the husband. However, it is always necessary that husband is more efficient and earning than the wife. In such cases, they need to approach the higher court pleading the revision of the case. The court have been allowing the revision application when the wife is at fault herself. Sometimes the wives leaves their matrimonial houses without any sufficient reasons and for their ill motive to get maintenance from their husband. There are some landmark judgments passed on the scope of the review as well. Numerous judgments have been passed by the courts supporting the contention of the husband. When they file revision application for setting aside or for the alteration of the maintenance amount when they are not satisfied with the order passed by the trial court. This certainly increases the scope of the revision which is available under section 125 of the CRPC. The Patna High Court in the case of Masood Ahmad versus State of Bihar, where the petitioner approached the High Court for setting aside the order which had been passed by the trial court directing the petitioner to pay the maintenance of rupees 3,000 per month to the ex-wife and rupees 2,000 per month as the maintenance for children. The petitioner had argued that his ex-wife, a teacher in a school, had been earning quite well. He contended that section 125 of the CRPC could only be invoked when the wife is not able to maintain herself. But in this case, she had been earning sufficiently well by working in the school. The court in this case held that the wife should not be provided with the maintenance as after the divorce the wife had sufficient means to maintain herself, and therefore the court set aside the order for giving rupees 3,000 per month as the maintenance. In another case of Arif versus Shahjad, the revision petition was filed before the Madhya Pradesh High Court under section 397 and section 401 of the Code of Criminal Procedure for setting aside the order which had been passed by the lower court directing the petitioner to pay rupees 3,000 for maintenance to his wife. It was contended by the husband that wife had deserted him again and had been living away from him for a long time. She did not have sufficient reasons to staying away from the matrimonial house. Then she even kept living and coming back to her matrimonial house. The court found that the action of the respondent wife was contradictory, hence the court allowed for the revision of the application. Revisional court also have the power to set aside the findings of the fact recorded by the lower court concerning section 125 of the Code of Criminal Procedure. In the case of Dev Narayan Haldar versus Asusri Haldar, it was held that the High Court in the exercise of its revisional powers can set aside certain findings of facts found by the lower court under section 125 of the Code of Criminal Procedure. It was held by the court that it is well settled that the appellate or revisional court, while setting aside the finding recorded by the court below, must notice those facts. And if the appellate or revisional court concludes that the finding recorded by the trial court are indispensable, they should record its reason for coming to such conclusion. Where the findings are findings of fact, it must discuss the evidence on record which justifies the reversal of the finding recorded by the court below. This is particularly so when findings recorded by the trial court are sought to be set aside by any appellate or revisional court. One cannot take exception to a judgment merely on the ground of its brevity. What if the judgment appears to be cryptic and conclusions are reached without even referring to the evidence on record or noticing the findings of the trial court? The party aggrieved is entitled to ask for setting aside of such a judgment. The court, however, does not have the power to exercise the power under section 125 of the CRPC if the wife has been granted the alimony under section 25 of the Hindu Marriage Act 1955. In this case, the wife has preferred alimony under the Hindu Marriage Act, and at the same time she opted for the maintenance under section 125 CRPC. It was held by the court that the wife has the right to opt for maintenance under section 125 of CRPC, and after that she could opt for the interim maintenance under Hindu Marriage Act. However, in this case it was the opposite, where the wife opted for alimony under the Hindu Marriage Act and then opted for maintenance. Therefore, in such cases, she can only be granted one relief, and that is of maintenance. That is why the decree for the alimony under this case will be converted into the suit for the maintenance under section 125 of the CRPC. The aforesaid judgment, the judges have provided us a glimpse of the changed outlook of the judiciary towards revision application and further increasing the scope by setting up more precedents. As a conclusion, I can say, although section 125 of the Code of Criminal Procedure protects the right of the wife and the parents to get the equitable amount of maintenance from the husband or their children respectively, there should not be any misuse of such provision. Nowadays, the scope of revision against the order passed under section 125 CRPC has increased, and the higher courts are increasingly accepting the revision application under section 397 for providing appropriate relief to the opposite party. There is no set rule which the court have been following in allowing or rejecting the revision application. It all depends on the facts and circumstances of a certain case. Sometimes the wife, even after the separation, has enough means to maintain herself. Some high courts had rejected the revision application filed by the husband because even after their ex-wife had means to maintain themselves, they still were required to give them the maintenance. However, in the above mentioned case laws, the High Court have approved the revision applications of the husband because the wife could maintain themselves. Therefore, the court decides it based on circumstances prevailing at the time. Hence, these precedents have increased the scope of the revision application against the order passed under section 125 of the CRPC. Although the authors believes that before invoking any such provision, the parties should solve the matter among themselves. Now, let us examine the recent judgment of the Honorable Supreme Court passed in the November 2020 in case of Rajneesh versus Neha. In that very judgment, the Honorable Apex Court has provides a very reasoned and detailed scope how and in what manner the 125 proceeding has to be decided, especially in view of the misusing the provisions of 125 by the claimant, especially the wives, who are even having the sufficient means to maintain herself, and by making the false claim, they filed the application suppressing their material income, and even they don't hesitate to file the false affidavit, which itself is an offense. And therefore, the Honorable Supreme Court in its judgment has provided to file a disclosure affidavit, detailed disclosure affidavit. There are three kinds of affidavit. One especially for the urban area, secondly for the rural area, and thirdly for the tribal estates, especially in the northeast states like Meghalaya. So let us focus on the first disclosure affidavit, which is meant for the urban areas, because in the urban area this kind of litigations are increasing day to day, and even the literate ladies, the claimant, they are not hesitating to file a false affidavit before the court in order to claim the maintenance from the husband. In the disclosure affidavit, it has been held that first of all, in support of the petition, the wife first has to file a disclosure affidavit disclosing in details the assets and liability in details. And after filing the detailed affidavit by the claimant, the respondent husband, after 4 weeks, he has also to file the disclosure affidavit. And after comparison of both the affidavit, if court finds that yes, there is a case of maintenance, the claimant wife has not sufficient means, since the averment made in the disclosure affidavit, if not rebutted by the respondent husband, then the husband has to the responsibility to support her wife by paying the maintenance. Considering this very aspect, especially the disclosure affidavit, if there is some misrepresentation or suppression of material fact, and later on it come to the court, either suo moto or at the application made by the respondent husband, a proceeding under section 340 CRPC can be initiated against the respondent wife. And after holding the preliminary inquiry, even without holding the inquiry, if the court is satisfied, then without hearing the opposite party, a court can file complaint before the competent court of my state. This law is settled in the Pritish Nandi versus State of Maharashtra, wherein the Honorable Apex Court has held that even without noticing the claimant wife who has filed the false affidavit, and prima facie, the court is satisfied that the false affidavit has been filed in the judicial proceeding, then a complaint has to be filed. And in this case, the plea of violation of principle of natural justice, the audi alteram partem, is not applicable, since the wife has the opportunity to prove her innocence in the court of competence by state itself. But in the recent judgment of the Honorable Supreme Court, it has also been held that giving the opportunity at the stage of hearing, it is a must to hear the other side also when a proceeding under section 125 CRPC is going to be initiated. In this very judgment also, there is details that how the proceeding is to be filed. The multiplicity of the proceeding has also to be ignored, considering the very fact that the multiple application is being filed, like the wife is used to file the maintenance application under the provision of the Hindu Marriage Act, in the Hindu Maintenance and Adoption Act, in the recent act of the recent, just I am forgetting the very recent act 2012, perhaps this act has come, wherein also the wife is to claim the maintenance, and the section 125 is the well known. So it has been held by the Honorable Apex Court, in order to avoid the multiplicity of the litigation, the wife can claim the maintenance only under one provision. Not the initially it was open that first they claim the maintenance under section 125, and then in the under the HAMA, and then the HMA, Hindu Marriage Act. But now the only one petition is maintainable by the wife under section 125 CRPC. So this is all about the scope of revision under section 397 CRPC against the order passed by the magistrate under section 125 CRPC or the order passed by the family court judge while exercising the power under section 125 CRPC. So कैसा लगा आपको? आप अपना विचार इस पे दें, आप अपना सुझाव भी दें कि मैं इस टॉपिक को और किस तरह से इम्प्रूव कर सकूं और क्या और भी चीज़ें इसमें मैं आपके लिए प्रस्तुत कर सकूं। अगले दिन फिर किसी टॉपिक के साथ मैं आपके साथ उपस्थित रहूँगा। तब तक के लिए आप सभी को नमस्कार, धन्यवाद।